What's the difference between a saving clause and a grandfathering clause? Basically, they're both types of transitional provisions that we find in legislation and ultimately in statutes. Basically, a saving clause is used to retain an existing right or authority that would otherwise be affected by a new law being enacted. In essence, the saving provision preserves the right or authority despite the new law's amendment or even repeal of that former law. On the other hand, California's Office of Legislative Counsel defines the term grandfathering as a legal exemption whereby a situation is governed by an old law while a new law applies to all future similar situations. In looking at a number of other states' bill drafting manuals, they use a saving clause to exempt existing rights or obligations or procedures from a new law's provisions, and this limits the application of the bill when it becomes law. In addition, a saving clause provides a means to enforce rights or to redress an injury, or even to correct or modify an existing law when the existing remedy is inadequate. The grandfathering clause, again, is a form of a saving clause, and it makes a statutory change inapplicable to those persons or entities whose rights were already established or to situations that have already occurred before the date of the law change. And normally, a grandfathering clause applies for a short period of time as part of that transition.